workplace. Our presentation today will be presented by Melissa McGuire of Wright, Constable, Skeen. Legal considerations for the evolving workplace discusses COVID, social issues, and the Biden administration, which are bringing about seismic changes in the workplace. This presentation will address how to navigate the legal implications of those changes, topics addressed, and will include FLSA, EEO, and practical implications of a post-COVID workplace. Changes at the Department of Labor, National Labor Relations Board, and the EEOC that will affect the workplace, expansion of LGBTQ protections, and immigrant law changes. Melissa is a partner at Wright Constable Skeen in the firm's Employment and Labor Law Practice Group. Ms. McGuire practices before federal and state courts and administrative agencies throughout Maryland, West Virginia, and the District of Columbia, representing businesses in all aspects of employment law. She aggressively defends claims alleging violations of wage and hour law, wage payment and collection law, family and medical leave law, employment civil rights, and breach of contract. She also defends employment tort claims such as wrongful discharge, negligent hiring, and retention and defamation. Ms. McGuire also regularly provides employers advice and counsel in all aspects of employment relationship, including disciplinary matters, leave, benefits, policies, procedures, wage and hour compliance, protection of confidential, proprietary and trade secret information, employment contracts, severance, unemployment benefit issues, hire letters, discrimination and retaliation, independent contractor classification, and employee medical issues. In addition, she also advises on the counsel to executives and professionals on unemployment contracts, compensation, restrictive covenants, and severance agreements. Ms. McGuire provides human resources training on topics such as effective documentation of personnel issues and avoidance of legal discrimination and harassment in the workplace. She also conducts workplace investigations of complaints of discrimination, harassment, and retaliation. Ms. McGuire has published articles on a regular basis and speaks on employment law topics. She has presented before the Maryland State Bar Association Annual Conference, the Bar Association of Baltimore City, and the Chesapeake Society for Human Resources Managers. She has been recognized for several years in the Maryland Super Lawyers publication, as well as Maryland Legal Elite by Smart CEO magazine. In 2016 and 2017, she was recognized by the Super Lawyers as the top 50 Maryland women attorneys. In 2017 as a top 100 Maryland attorney. In addition, she has been recognized by the Best Lawyers in America, and her personal firm was previously recognized as a Tier 1 Best Law Firm Employment Law Management by the U.S. News and World Report. She is also a member of the Labor and Employment Law section of the American Bar Association. She also serves as the intermediate past chair of the Labor and Employment Law section of the Maryland State Bar Association. We will start the legal considerations for the evolving workplace. At the end of today's presentation, there will be a question and answer session. Please feel free to type in any questions into the chat box, and we will address those at the end of the presentation. And we'll hand it over to Ms. McGuire. Thank you.
Thank you, Basil. I'll have to ask them to summarize what they send over to you. It makes me feel old listening to all that list. Zevi, if you could change the slide, and I think we could go past the first slide, which has a little overview.
Okay.
So I can, while Zevi works on pulling up the PowerPoint presentation, since I am a lawyer, I have my fine print disclaimer that I have to read to you. And as I was mentioning to Basil and Zevi earlier, things have changed. I used to give these presentations and not have to give my disclaimer. but now they're posted on the internet so people can watch the webinar. And so I have to let them and you know that this webinar is provided for informational purposes only and is not legal advice. Participation in the webinar doesn't create an attorney-client relationship between Wright, Constable, and Skeen, or me and the participant. The general opinions expressed at or through the seminar are the opinions of the attorney and may not reflect the opinions of the firm or any individual attorney of the firm. And most importantly, I'm going to be speaking about general legal principles, and your particular situation may be different based on facts, specific facts. So that's why it's important not to make individual decisions based on a specific fact situation on general information we're discussing today. So this is to give you an overview so you understand the issues and the laws that are changing. Next slide, please. So today we're going to discuss new leadership at each of the federal agencies that apply to the workplaces in the US that are covered by federal law. So the Department of Labor, which applies to all employers, the EEOC, the Equal Employment Opportunity Commission, and the National Labor Relations Board. Those are the three primary federal agencies that that oversee and implement the regulations and enforcement of the federal employment statutes. We'll talk about the return of pay data collection and the pay equity initiatives. We've seen some of that in Maryland. We were starting to see that in the Obama administration. Trump, it went away, and with Biden, it's going to come back again. Gender expression and sexual orientation under Title VII. We'll talk about a little bit about that and how that's changing. Title VII, if you're not aware, is the federal statute that applies to employers with 15 or more employees. There's usually a state and local variation of it, but Title VII is a federal law that prohibits discrimination on the basis of race, color, national origin, gender, and religion. Recently, there's been some changes under Title VII where the Supreme Court's addressed whether gender expression and sexual orientation are covered by Title VII. We'll discuss the Americans with Disabilities Act and COVID, the effect of National Labor Relations Board changes. Again, that's something that there was some activity under the Obama administration that was very pro-labor. I don't want to say anti-management, but it made things more difficult for management. And we're going to see a swing back to that now under the Biden administration. There's going to be changes for union organizing and elections. Again, started under Biden. Trump pretty much put a stop to it all, and then it's starting to open back up again. And then there's been state law changes in the state of Maryland. The General Assembly just ended about a week and a half ago. So there's been some state law changes. And we'll talk a bit about a District of Columbia law change that is important for two reasons. One, if you have employees employed in the District of Columbia, it applies to your employees. But two, I think it's the wave, it shows a trend that we're going to see nationally and in the state of Maryland. And then finally, we're going to discuss some immigration law changes. I'm not primarily an immigration law lawyer. We have a really good immigration law lawyer that we recently brought on board. She's nationally renowned. So I think she's going to be very busy with the immigration law changes that are on the horizon. Zevi, thank you. So some of the first things that happened under the Biden administration is obviously he wanted to change the leadership at the different federal level agencies. The EEOC General Counsel under the Trump administration was Sharon Gustafson, and she was someone who advocated religious freedom. Now, I didn't see her out there advocating religious freedom for religious minorities. Her big push was religious freedoms on behalf of Christian owned entities, such as, and a lot of that was seen as protecting the right of Christian employers to treat people who are different sexual orientations differently based on the belief that the Bible prohibits that. So that was kind of her push. It was more of a far right version of religious freedom that she was advocating. And then the NLRB General Counsel, Peter Robb, was very pro-management. So both Gustafson and Robb were fired by the Biden administration. All right, I've got a question. We have a small studio with 20 people. Can we legally open the office only to fully vaccinated people, with the unvaccinated continuing to work from home as they had been during the last year? And can we ask employees whether they are vaccinated? We're going to discuss this issue, but I will go ahead and answer this now. We're going to talk about vaccines and the ABA. With 20 people, you would be covered by the Americans with Disabilities Act because you have more than 15 employees. You can open the office to fully vaccinated people, and you can permit the people who haven't been vaccinated to continue to work from home if they so choose. And yes, you can ask employees whether they've been vaccinated. As we'll discuss a little bit further, the ADA, under the ADA, the EEOC issued guidelines several months ago, and they did make clear that asking about vaccination status is not an unlawful medical inquiry. Now, if you ask someone why they don't have a vaccine, then you can get into the medical inquiry piece, because it may elicit the fact that someone has a disability that would preclude them from getting the vaccine. So that's the short answer to that question. And we will, like I said, we'll talk a little bit more about that because this is becoming more the issue now, vaccinated versus unvaccinated returning to the workplace. So getting back to the overview of the agencies under the Biden administration and the direction that these employment agencies which are responsible for interpreting and enforcing the discrimination and other employment laws. So the people that have been hired to replace those that have been terminated, and then folks under them that have voluntarily resigned because they were political appointees. EEOC Director Charlotte Burrows, Acting EEOC General Counsel Gwendolyn Reams, the CCP Director Jenny Yang, and she's significant because she was a strong advocate for wage equity when she was at the EEOC. The OFCCP is the federal agency responsible for overseeing federal contracts. So I'm not sure how many of you, I'd imagine at least some of you are federal contractors or subcontractors. And so the OFCCP makes sure that contractors are complying with the anti-discrimination and also affirmative action requirements of various anti-discrimination statutes. And the fact that when she was at the EEOC, she was an advocate for wage equity. That suggests to me that OFCCP is going to be asking for and looking at wage issues to determine wage equity between male and female employees. Again, that was a big issue that the Obama administration was focusing on, and because Trump took office before some of those initiatives really took root, I think we're going to see a return to that once things settle down and the transitions within the administrations are fully settled. The acting NLRB, Acting General Counsel, Peter Orr has already rescinded several 10 Trump-era memos regarding the National Labor Relations Act, and the Biden administration has made no bones about the fact that he's very pro-labor, and don't think, and it's a common misnomer for employers to think that I don't have a union, so the National Labor Relations Act and the NLRB aren't relevant to me. That's not true. There are requirements that and laws, pieces of the law that do apply to private sector employers that do not have labor unions or that have not been organized or been the target of a organizing campaign. So this does affect, and we'll talk a little bit later, how this affects private employers who do not have a union or an organized work site. The permanent general counsel nominee for the NLRB is Jennifer Abruzzo. She's very pro-union. So again, we're going to see a lot more pro-union, making it easier for workplaces to organize, for labor unions to organize workplaces, and also effects on policies that apply to employers who don't have unions or organized workplaces. The pay equity initiatives. So as I mentioned, under the Obama administration, and this has really been a nationwide push, Maryland has passed pay equity legislation and has laws that you can't discriminate in wages based on gender. So it is back in the spotlight. And in addition to gender pay equity, which was a big issue under the Obama administration, due to recent social justice movements over the last 5, 6, 7 years, racial pay equity, I believe, is going to be also a big initiative under the Biden administration. And what does that mean? You'll see up on the screen EEO1 forms. I'm not sure how many of you may be required to file an EEO1 form, but that's a document that the EEOC requires employers with 100 or more employees to file every year, or employers that have government contracts that beyond a certain threshold. Once you pass 100 employees or you get certain government contracts, you have to file an EEO1 form every year. And traditionally, the EEO1 form asks you to provide data to the government about the racial and other breakdowns of your workforce as opposed in what types of jobs in different job categories. So for example, management and then different levels of jobs, they asked employers to provide data on the breakdown in the different protected classes on that information. Well, under the Obama administration, in order to fight the pay equity discrepancies, they were going to significantly increase the burden on employers to provide not only the data on protected factor breakdowns for this data, but also pay information on the different categories for employees, which would be quite intensive to go through and provide pay data in addition to other data. And the goal being to come up, so the agencies could come up with data to get a better idea of the actuality of pay discrepancy and addressing pay discrepancy. And also, forcing employers to take a look at, hey, are we paying women differently than men, and why, and then what positions? And then the Paycheck Fairness Act was introduced in January of 2021. That's been passed under the Trump administration in the House, but it went nowhere in the Senate. Now we have a Senate that's also controlled by the Democrats, so there is a chance that it could be passed. And if you could proceed to the next slide. So the pay equity information, in order to justify a wage differential, the employer under this new proposed legislation would have to show business necessity, which is a higher standard. It's already unlawful under Title VII and the Equal Pay Act to pay someone differently based on their gender. But there's a relatively easy burden to show and to be able to demonstrate that you have a legitimate basis for doing it. That the federal statute, the proposed federal statute, would make it harder to justify a differential in pay between male and female employees. And I also wanted to mention under state law that there is last year pay equity legislation was passed, and it is state law in Maryland that you cannot ask an applicant to disclose their pay information. And the thought process behind that is that pay disparity kind of tends to self-perpetuate. So a woman working at a job where she tended to be paid less than the male employees, she goes into the next job and the employer says, well, how much were you paid there? $30,000. Well, $30,000 becomes the bargaining point, and that was artificially low because she was being paid, improperly paid at a lower pay rate at the prior job. So it tends to, this is an effort to end the self-perpetuation of the disparity in pay. So employers aren't permitted to ask an employee what he or she made at their prior job. And also employers have an obligation, if an applicant asks, to provide the pay rate range for the job for which they're recruiting. So applicant asks, what's your pay range for this job? And an employer may have to say, well, we're looking to hire someone in the $80,000 to $90,000 range or some type range. So that's under Maryland law, and it is becoming under the federal law. It would also be required, but right now it's just state law. Other labor initiatives, if you could go back, please. I'm sorry, I jumped the gun on the prior slide. So just recently on the federal front, Biden just last week issued an executive order increasing minimum wage on federal contracts to $15 an hour. You know, everybody, I think, is, I'm sure you're aware that over the last maybe 10 years, there's been a labor initiative to increase the federal minimum wage to $15 an hour. Maryland, we have kind of a hybrid where we are incrementally increasing the minimum wage. I think it's at like $11.75 at this point, but the end point would be $15 in a couple of years. Well, Biden last week issued an executive order saying that employees on any federal contracts must be paid $15 an hour. On that Fair Labor Standards Act front, which is the federal law that requires minimum wage and overtime to non-exempt employees, there's a state version of that also, like many of these federal laws. But Biden suspended a lot of the proposed rules that Trump had in the pipeline on tipped employees, and more relevant, I think, to probably your business is independent contractors. He had proposed final rules on independent contractors that were more favorable to businesses that wanted to classify workers as independent contractors. So a lot of the gig industry jobs would, under his proposed regs, would most likely fall under independent contractors. So that rule has been suspended. So we are kind of back to where we were before with the sticky issue of who's an independent contractor and who's an employee. Next slide, please. So those of you who haven't heard, the Families First Coronavirus Recovery Act, which became law April 1st, 2020, has been extended. Initially, it expired on its own terms at the end of the year, December 31st. And then it was extended once to the end of March. Well, it's been extended yet again. This time on a voluntary basis. The initial extension in March was voluntary. The second extension has been, it can be extended on a voluntary basis as well. A lot of my clients who voluntarily extended the first time have opted not to this time, although a couple. And one benefit of extending it is that in addition to extending the duration of the benefit leave, and it would also provide new leave under the act, whereas the first extension, employees who hadn't exhausted or used the initial allotment of FCRA leave could use whatever they haven't used yet. Under this new extension, employers who opt to adopt the new extension have to give a new corral of leave for employees. And also it extends the reasons that the leave can be used. So in the initial round, employees could only use the emergency family medical leave to provide care for children who have, because of schools closings or daycare shutting down or restrictions, or, they could use it for that. Now they've extended that emergency family medical leave that can be used for any of the other leaves provided under the emergency leave piece of the act. Again, it's non-mandatory. The one positive, not the one positive, one of the positives in adopting the extension, in my view, is that employers, it was extended so that employees can use it to get a vaccine or to recuperate from any side effects from a vaccine. And it is a way for employers to incentivize by providing leave for employees to get a vaccine and have a tax credit applied to that. So they would get a tax credit for permitting their employees some leave to go get the vaccine, or if they become ill from the vaccine, to stay home for a couple of days, because I know a lot of employers have been struggling with ways to encourage employees to get vaccines. And there are some issues, because if you pay them, then that's subject to taxes, or give them gift cards, that's subject to taxes. So that's one positive from the extension of the act. Next slide, please. So ADA and COVID-19 vaccines. Now that the vaccines are, at least in Maryland, pretty much readily available to all adults, anyone over 16, which would be pretty much the workforce, there have been issues that have arisen, such as one of our participants asked earlier, can we make the limit in office or return to folks that have been fully vaccinated? The answer is yes. You can ask folks if they've been vaccinated. That's not a medical inquiry. You may have to provide a reasonable accommodation. If you want to mandate vaccines, you'd have to provide a reasonable accommodation for folks who can't get the vaccine due to a disability, or if someone cannot receive a vaccine due to a religious belief. In that instance, you can ask for information relative to support the claim of disability. As far as religious belief, I wouldn't go down that road, but you may have to provide a reasonable accommodation, and permitting work from home is a reasonable accommodation. Maybe putting them in an office that's in an isolated area from other workers could be a reasonable accommodation. So there's several different options. And if you do have a question, you should talk to legal counsel, because I have seen, and I know some of my colleagues have seen, charges of discrimination related to COVID-19 vaccines and requiring people to come to the office or come to the workplace when they have concerns about COVID, including they may have family members that are vulnerable, and they're afraid to come to the workplace because they don't want to bring COVID home. So there have been, I'm sure everybody's heard the news, there have been looser restrictions now in Maryland, and guidance from the CDC about, what you have to do after you've traveled, or if you have been in larger groups, as far as, isolation and receiving a test. So those restrictions in some areas have lifted, but you still should be careful, because each county has its own rules and regulations, some of which aren't easy to find on the internet. So if you are wondering about certain situations with your workforce, you should at the very least look at the CDC and probably consult with legal counsel. And also OSHA. OSHA has issued guidance on safety measures in the time of COVID, because under the Occupational Safety and Health Act, employers have an obligation to provide a safe workplace free from known harm. Next slide, please. Unemployment expansion. So back initially last year when when COVID became a pandemic, obviously the government passed legislation offering $600 additional per week for unemployment benefits. Now they have expanded them again, but not so much. I think it's 300 is the cap now. But still, when you add that to state benefits, it can be pretty significant. And I think it is starting to cause an issue with some employers in the service industry having difficulty recruiting workers because, frankly, it's not, there's not much of a return in compensation to go to a job as opposed to receiving unemployment benefits. And under the federal law too, they've expanded coverage so that employees who don't return to work because they're concerned about the risk of COVID to them may also become entitled to unemployment benefits. One thing I did want to mention right now on the unemployment front is there has been a phenomenal increase in fraudulent claims. So you may be seeing unemployment for someone that's a claim for someone who's currently employed by you, one dating back to December, an owner, and there have been all kinds of fraudulent claims being asserted, filed with unemployment. And the reason of that is if you think about it, last year when COVID first surfaced and everybody was working from home and people were losing their jobs, the Department of Labor Licensing and Regulation, which now is called the Maryland Department of Labor, they too were all going home and working remotely and trying to get used to that world. And unlike those of us in the private sector, there wasn't as much of it going on, and they weren't as technologically equipped to that. So you've got the workforce who's responsible for processing an unprecedented number of unemployment claims also being thrown into an environment that they weren't familiar with, where technology was challenging. So what they were doing at the time is they were erring on the side of granting benefits because there was just this influx of people who were losing their jobs, and obviously they wanted to make sure people who were entitled to benefits were getting benefits. Well, some fraudsters decided to take advantage of that, now are filing unemployment benefits. And fortunately, the Department of Labor is getting a little more organized, and they are going after fraudsters. But it's very important, if you do get a claim for unemployment benefits that looks questionable or could be fraud, that you report it to the Maryland Department of Labor, because there are concerns that in order to file for these benefits, they have somehow access employee and owner social security numbers and other private information. And it's my understanding that they have been able to track down some of the fraudsters using the computer that they're using. So, but in any event, you should do that to make, just so that you also don't get dinged with a higher rating for claims being filed against you, which would lead to higher unemployment taxes down the road. Next slide, please. The National Labor Relations Board, I told you in the beginning of the presentation that there has been a changing of the guard. They're still being vetted and it's not final, the new people that are being appointed by Biden, but most of them probably will be. Needless to say, there'll be a more union-friendly National Labor Relations Board. There will be more union-friendly legislation introduced by Biden. And again, the House, the Democrats have a nice majority in the House from their perspective. The Senate is also balanced on behalf of the Democrats, but I don't think it's going to be a slam dunk for them to get things passed from the Senate, but it is more possible. It is more possible than it was to get some of these more labor-friendly pieces of legislation passed. And in any event, the agencies, the National Labor Relations Board itself, once the current chair, the current board runs through and Biden starts appointing board members, it's going to be more democratic, more union friendly. So I'd say in about a year or so, we're going to see more decisions and guidance coming from the NLRB that's going to be pro-union. And also Biden has and will issue more executive-friendly, union-friendly executive orders. Now, why do you care as a private employer if you do not have a union or a union organizing drive in your workforce? Why do you care about the National Relations Act? Well, one thing, it protects all employees. It protects their right to collectively communicate about the terms and conditions of employment. So what does that mean? You can't have a policy that prohibits two employees from discussing their pay. I've seen that, and I've heard employers tell employees that that's unlawful under the National Labor Relations Act. So that's one example of where the act applies in a private sector employment setting where there's no union. Another place that it affects you is in your policies. So under the Obama administration, the board, the National Labor Relations Board, was finding unfair labor practices when employers had policies, in particular social media policies, and I know that's very important to everybody now. I've written a lot of them in the last year between civil rights movements and COVID and political issues. It's become an issue for employers because their employees are on Facebook and other social media platforms making comments, as well as members of the public making comments on social media boards or websites or whatever that the employer has. So under the Obama administration, the NLRB was saying that many policies that on their face appeared to be neutral as far as labor policies violated the National Labor Relations Act because they could be used or they could be construed to limit or restrict employees from discussing the terms and conditions of their employment. So for example, a policy that said you can't state anything on social media that defames the company or that puts reflects the company in a negative light. Under the Obama administration, the board was saying that violates the National Labor Relations Act because that could be construed to prohibit employees from discussing the terms and conditions of employment on social media. So it does affect private employers, and it's something to be aware of, especially as you develop and try to implement social media and other policies that could implicate employees discussing the terms and conditions of employment. Biden immigration initiatives. As I mentioned earlier, I am not primarily an immigration lawyer. I know enough immigration law to guide employers to where they should be as far as an immigration lawyer and what are some obviously illegal practices. But I think this group should be aware of new immigration initiatives. So Biden has come in and he's delayed publishing Trump rules that haven't taken effect, but we're in the planning stages and the about to take effect stages, including rules that eliminated the H-1B lottery. And he also proposed to rescind workplace authorizations for the spouses of H-1B workers with green cards. So again, I think that's more helpful to businesses that he's pulling back, that Biden is pulling back on some of these restrictions. Biden's also revoked the travel restrictions from 13 countries. That has created an issue for employers that may need employees from those countries. So initially there were a lot of the countries were Muslim based, which was in the news because it was construed as a Muslim ban. But no, those countries that were on that list, that restriction has been revoked. So you can assuming they otherwise qualify, you can bring in employees from those countries. And then most significantly, he introduced the U.S. Citizenship Act of 2021, which, among other things that really applies to employers and affects employers, is creating a pathway to citizenship for Dreamers. I know there have been some employers that have had concerns that their employees are going to have to leave the country because they came in as children, and they were talking about not permitting them to become citizens. So next slide, please. So again, I mentioned earlier, we talked about a lot of the federal laws and changes under the Biden administration. I also wanted to give some attention to the state laws, because if you're employed, you're a Maryland employer, or you have employees in DC, you have to be cognizant of those too, because some of those laws are more stringent than their federal counterparts, and they apply to more employers than the federal counterpart. A lot of the federal civil rights laws apply to employers with 15 or more employees, but some, and the state law does, anti-discrimination law does too, but there are some local jurisdictions that apply to smaller employers, to as few as who have as few as one employee. So in any event, one of the major changes in this last legislative session was that the General Assembly extended the deadline for filing a charge of discrimination with the Maryland Commission on Civil Rights from 6 months to 300 days, which brings that in line with the federal law. So under federal law, Title VII, ADA, those types of civil rights statutes, you have 300 days if you're in a state with a work sharing agreement with a local agency, which Maryland is. There's a 300-day deadline for filing a claim, and this just extends that to Maryland's Maryland Commission on Civil Rights. The Maryland, there we go. Also, during this General Assembly, they passed an amendment to the Maryland Flexible Leave Act, and to require employers with 15 or more employees who otherwise have leave. So this isn't requiring you to provide leave if you don't already have a leave program, but if an employer already has a leave program like PTO or paid vacation, even sick leave, that they have, an employee has a death in the family, the employer has to provide at least 3 days of bereavement leave for those employees. And that applies to employers with 15 or more employees. So if you have 15 or more employees, and you already have some type of leave that you offer other employees for other circumstances, you have to permit employees to use that leave for bereavement leave if they've got a death in the family. So another state law that I wanted to mention, it's not a new state law this year, but it's relatively new. And with COVID last year, it didn't come across the radar screen of a lot of employers, but Maryland also has passed a new law on non-compete, restricting non-compete agreements. The Maryland law restricts it to employees who make above $15 an hour. So you can't have a low wage employee making $10 an hour subject to a non-compete agreement. And DC, more importantly, because a lot of Maryland employers sometimes do have employees who work in the District of Columbia. So if you have a District of Columbia office, or you have an employee that works in the District of Columbia, the District of Columbia recently passed legislation that prohibits non-competition agreements and employment contracts. There are very few exemptions, and that includes for healthcare workers that make over $250,000 a year. So high-paid doctors, you can have a non-compete. But generally, in the District of Columbia, non-competes are no longer permitted. They're no longer valid. So that's something to keep in mind, and make sure your agreements are up to date. You can still have It's very important to still have contracts where employees are required to keep your confidential information and your trade secrets secret and confidential. And you can have non-solicitation provisions, but you can't have non-competes. So that's something important I wanted to bring to your attention because it's kind of gotten lost. And that is another initiative that Biden has talked about now, whether I think he has bigger fish to fry in the next couple of years, whether that actually gets some traction, I question, but that is on his agenda and that was on his agenda during his campaign. So he's talking about a federal ban on non-compete agreements, which I think in your industry you should be aware of because I know there's a lot of non-competes and other restrictive covenants in your industry. So you have to make sure your agreements are up to date so that you can enforce them to the greatest extent possible to protect your proprietary and confidential information and goodwill that you generated with your clients. Next slide, please. I think that's the end. So we have some time. If anyone has any questions or comments, I'm more than happy. Hopefully I'll know the answer. If not, then I can always look it up and get back to you later. And also feel free to reach out to me. My contact information is there if you have questions on any of these issues or any other employment law issues. And if we have none, then I will turn it back over to our host.
There you go. Thanks, Melissa. It was a great presentation. Oh, there you are, Basil.
Well, thank you, Melissa. Thank you for that wonderful presentation. If there's any additional questions, I don't see any more in the chat box, but if you have any more questions, there's Melissa's contact information. And we hope you found this informative and timely.
And I guess if there's a takeaway, if I can jump back in, because I'm a lawyer and that's what we do, we talk a lot. If there is a takeaway, just please make sure your employee handbooks are updated and that you look at your employment agreements to make sure they're enforceable, particularly as it relates to your confidential information, work products, and proprietary information. Thank you.
Great. Thank you, everyone. One of the questions is asking if you wouldn't mind expanding a little more on the new COBRA health insurance eligibility.
To be honest with you, I don't know a whole lot about that, other than I know that there are funds available to help employers help employees with the COBRA payments, because as you know, one of the big concerns and issues when someone loses their job is paying their benefits. And while it's nice to have COBRA, essentially what happens when an employee qualifies for COBRA, they pay the whole nut, including what the employer has paid before. And now the government has offered assistance, and I believe it's a tax credit, but I can answer specific questions about that. If you want to shoot me an email. All right, great. Okay. Well,
Okay.
Thank you, everybody. Have a great day.
Thanks, everyone.
Thank you.
Bye.